May it please you.
Yes, Mr. Patel.
Lord, please have my written submission. I am appearing in item 501.16. Review in writ petition 414. 501.16.
One minute. Number?
501, everybody is in 501, but it's 0.16.
Fine. How many matters are there?
There are total 31, but they are all seeking review of Dhirajmore. So basically, my lord, these are all people who had applied, who got interim orders and undertook the process, but ultimately their writs got dismissed. So they lost. Now, my client, my lord, I'll just tell your lordships in a nutshell. Actually, if your lordship answers the fourth question, then all of us on this side are covered anyway. But there is just one proposition I want to put before your lordships of what the law, how it was understood and why we were debarred and why, according to us, that law was not correct interpretation of the constitutional provision. Now, my client, my lord, he joins practice, he's enrolled in the year 2000. My list, my written submission, my lord, para 2, if your lordship will have the very first page quickly, just to highlight the stagnation, my lord. Sandeep Kumar, my lord, he's enrolled with the Bar Council of Uttar Pradesh in the year 2000. He enters it should be Uttarakhand, my lord. He enters the Uttarakhand Judicial Service as a civil judge junior division in March 2009. He is promoted senior division in April 15. And from May 25, he's a chief judicial magistrate, but he's still serving after all these years in the same position. He applied, my lord, serial number 3I. He applied in pursuance to the advertisement of May 2016. He was not allowed to compete. He filed this writ petition under Article 32, 414 of 2016. And by interim order of 15 July 2016, your lordship allowed him to participate in the process of selection. As per his knowledge, my lord, what is commonly understood there and known, he was second in the overall merit. Doesn't matter. He lost the petition and therefore he lost out. Now, my lord, why were people like me? My case.
You are also part of Dhirajmore.
Yes, we were part of Dhirajmore. My case is that I have 7 years prior to being appointed as a civil judge. I say that I do not want any benefit of my period as a civil judge towards my appointment as an additional district judge by way of direct recruitment. I further say I am willing to meet all conditions of eligibility which are prescribed in the advertisement, age, educational qualifications, etc. I am only being excluded from consideration on an interpretation of the expression has been, which occurs in Article 322, has been an 233, has been an advocate for 7 years, is interpreted in para 102 of the judgment in Deepak Agarwal, which Mr. Datar read to mean it is a situation which should be continuing in presenti on the date of the application. And it should remain continuing up to the date when you actually seek appointment and are appointed. And because a person who joins the judicial service is not continuing as an advocate on that date, therefore he is rendered ineligible. Now, just kindly see that expression, my lord, how it appears. And I will straight away take your lordships. In fact, Rameshwar Dayal also considered this. And what Rameshwar Dayal observed, I was at that point when it was read, not here, but I'm told my lord, the Chief Justice had pointed out that para, that it's an organic document which needs to be considered and does not need a narrow construction. And that it refers to a judgment of the Allahabad High Court, which exactly says what we are proposing. Now, again, I sound a caveat by saying, if your lordship answers question 4 in favor of the view expressed by my learned friend, Mr. Bhushan, my lord, then of course we are all eligible. Then there is no problem. But equally, just kindly see, my lord, the Article 233 subclause 2. A person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Has been is interpreted to mean a continuing process, a situation which had existed and is still continuing. Our submission is has been is not capable of that interpretation. Has been, unless it is followed by a participle, which is a verb ending in ing, it refers to a situation which has happened in the past but may not necessarily be continuing as at present. In contradiction to the use of the expression is. To give your lordships a homely example, in so many statutes which provide for former judges to be appointed in tribunals and commissions, the expression used is has been a judge of the High Court, has been a judge of the Supreme Court. Some, of course, use is and has been. Now, if the interpretation which is given here is accepted, then it can only mean a person who is a sitting judge, which is not actually what it has been understood to mean and does mean, and what it should mean. Now, my lord, I will straight away go to Rameshwar Dayal, my lord, where this argument was raised for the first time and what the court had to say. I have reproduced that part in my written submission, my lord. If your lordship will have page 2 of my submission. Para 3, the judgment is also there, but the relevant part I have reproduced because there is something there which I just see page 2, para 3A. In my lord, sir. It's I gave a hard copy, my lord. Otherwise, it is 4579. But kindly take the hard copy; it's much better.
Just skip 4 to 7.
I have.
Submissions also.
I have one more. Your lordship.
Yes,
Yes. In paragraph 8,
yes,
page 2, judicial precedents governing the issue,
Yes.
page 8, para 8.
yes,
Secondly, he has submitted that by reason of the use of the present perfect tense has been in clause 2 of article 233,
yes,
the rules of grammar require that the person eligible for appointment must not only have been an advocate or pleader before, but must be an advocate or pleader at the time he is appointed to the office of district judge. Now, this is dealt with in only one paragraph, and that relevant paragraph I have quoted. It is perhaps necessary to add that we must not be understood to have decided that the expression has been must always mean what learned counsel for the appellant says it means. According to the strict rules of grammar, it may be seriously questioned if an organic constitution must be so narrowly interpreted, and the learned Additional Solicitor General has drawn our attention to other articles of the Constitution like Article 5C, where in the context the expression has a different meaning. Our attention has also been drawn to the decision of the Allahabad High Court in Mubarak Mazdoor, where a different meaning was given to a similar expression occurring in the proviso to subsection 3 of section 86 of the Representation of People Act 1951. We consider it unnecessary to pursue this matter further because the respondents are now considering continued to be advocates of the Punjab High Court when they were appointed as district judges, and they had a standing of more than 7 years when so appointed. They were clearly eligible for appointment under clause 2 of article 233 of the Constitution. Now, my lord, so therefore they don't answer it finally. They refer to Mubarak Mazdoor. Now, Mubarak Mazdoor, my lord, I have quoted, attached at internal page, after para 16, page 16, the next judgment. It has gone somewhere else. It's 4594, but it's just after page 16, the written submission. In this compilation itself, if your lordship will have, just have one paragraph of that judgment with me, my lord. Para 2 and 3. It is here with the reference number.
Yes, yes. Service number is available.
All right, page 4.
Not necessary at all. We'll tell you why.
I quite see it.
We'll tell you why.
Yes,
You were judge, working as a judge now, as of now.
correct,
Judge.
correct,
So obviously you're not a lawyer as of now.
correct.
What we are trying to tell you is that this subsection 2 of 233 only speaks about lawyer. How far that principle can be imported into by considering other things is a different issue. Anyway, that qualification is not for you, but any case, because considering the larger interest we are trying to at best we can import into that. Therefore, it's not necessary at all.
All right, I quite
Yes,
see
yes,
that.
that's what it is.
I quite see that. Very quickly then, therefore, may I tell your lordships, now what happened
Once you are not a lawyer, there is no need for this.
I'll just tell your lordship then how the law has developed over the years, my lord, so
Yes.
that your lordship has that perspective also. So Rameshwar, actually, if I read Mubarak Masih, Mubarak Mazdoor,
Yes.
the clause which was being interpreted was that if the election commission considered it expedient so to do, it may appoint a person who has been a judge of the High Court as a member of the tribunal. That is 4595. This was the expression under interpretation. It was argued has been means in presenti. So because whom person you have appointed is a former judge, he has been a judge, therefore his appointment is bad. That argument is rejected by saying that the has been when not followed by a participle in the present perfect tense and accordingly indicates that state of a being has existed and may not necessarily be continuing. So therefore that was the point. Now, what happens as a matter of fact is, my lord, that this in Deepak Agarwal para 102, your lordship, though the issue there was totally different, whether district attorneys, additional district attorneys, public prosecutors are advocates. While concluding that judgment in para 102, your lordship said has been means in presenti. All judges got excluded.
That Mr. Dagar has already argued.
Yes. So then, my lord, after Deepak Agarwal said that, came Vijay Kumar Mishra's judgment, division bench judgment of this court. In Vijay Kumar Mishra, what had happened and exactly what my lord, the Chief Justice had said, Vijay Mishra applied for being appointed as an ADJ. The process started. The process could not conclude over a year. In the meanwhile, he also applied for being appointed as a civil judge. He gets appointed as a civil judge. After his appointment as a civil judge, he is called for interview of ADJ, which he had applied earlier, but the process went on. When he had to seek permission from his present employer. The High Court said first resign, then go for interview. He files a petition in the High Court, which is rejected. He comes here. Your lordships take a view that there is a difference between a process of selection and appointment. The constitution bar will apply at the stage of appointment, but not at the process of selection. You can apply, you can compete in the process of selection, but if you are appointed, you resign and you join. Now, that judgment then held the field for a short while, but subsequently,
He was appointed then.
Vinay Mishra was appointed.
He got the benefit.
Yes, he got the benefit of that. No, Vinay Mishra won. Vijay Mishra won. Why? He could not have been selected, but the ratio of law comes in his favor, and it is said you can compete. If you are selected, you resign and you join. So the ratio of law in that judgment is in favor of people like me. But in Dhirajmore, that is specifically overruled by relying on para 102 of Deepak Agarwal, saying has been means in presenti. But in Dhirajmore, there is a very interesting observation in para 76.6, which I do want to read to your lordships, my lord. Just Dhirajmore is at page 99 of my compilation.
Dhirajmore must be there also in the main compilation.
That's SCR.
Here it is SEC.
Yes. Now,
Yes.
now kindly see in the concurring judgment, if your lordship wants to make a note, this Vinay Mishra is overruled by the main judgment in Dhirajmore
One
in
minute.
para 24 and
1 minute, 1 minute.
now if your lordship will see para 24 at page 132, the concluding para. At page 132 of my company.
Para?
This one is not concluding.
Pardon?
Which paragraph?
Para 24 at,
24 is not the concluding statement.
no, it's not concluding.
Yes.
I'm just saying this is where the learned judge considers Vinay Mishra para 24 at page 130
Yes.
and 132. Kindly have after the extract. We find ourselves unable to agree. The concluding I'll show. That is para 47.6. I'll show that also. We find ourselves unable to agree with the proposition laid down in Vijay Kumar Mishra. In our opinion, in-service candidate cannot apply as against the post reserved for advocate pleaders.
So no, you are reading para 24.
Yes, Manoj. The last conclusion of para 24 at page 132,
Before 25 starts.
just before 25 starts.
Yeah.
Your lordship has the SCC. Yes. We find ourselves unable to agree with the proposition laid down in Vijay Kumar Mishra. In our opinion, in-service candidates cannot apply as against the post reserved for advocate pleader, as he has to be in continuous practice in the past and at the time when he has applied and appointed. Thus, the decision in Vijay Kumar Mishra cannot be said to be laying down the law correctly. Then in conclusions, my lord, in para 47.6 at page 143, again the same thing is reiterated.
1 minute.
Page 1005.
It is at page 143.
Yeah, this one here, it is a separate.
Yes.
But significantly, my lord, there is a concurring judgment by Justice But now his conclusions start from page 159. I want to draw your lordship's attention to conclusion 76.6. Para 76 is his conclusions.
Yes.
1 minute, 1 minute.
26.6.
Yes. Ma'am.
This, what is para?
76.6. Significantly, may I read this because it's important. It's the opening part will say something which is in favor of what I am trying to canvass before your lordships. Significantly, Article 233(2) ex facie does not exclude judicial officers from consideration for appointment to the post of district judge. It's very important. This Justice Bhatt therefore reaches a different conclusion. It, however, equally does not spell out any criteria for such category of candidates. What your lordships had observed also. So there his conclusion is in support of what is what the submission is. But how does he oust us? By have been. That you are not in continuous practice, therefore you are out. And now I'll read this. This does not mean, however, that if they or any of them had 7 years practice in the past, they can be considered eligible, because no one amongst them can be said to answer the description of a candidate who has been for not less than 7 years an advocate or pleader. Per Deepak Agarwal, that is, that the applicant candidate should be an advocate fulfilling the condition of practice on the date of eligibility condition or applying for the post. The sequitur clearly is that a judicial officer is not one who has been for not less than 7 years, an advocate or pleader. So this relies on Deepak Agarwal. In my written submissions, my lord, I have dealt with the judgment in Deepak Agarwal. My submission there is, this issue never arose in Deepak Agarwal. Neither is the para of Rameshwar considered. Rameshwar relies on the judgment of the Allahabad High Court in Mubarak Mazdoor. Mubarak Mazdoor clearly says it is not in present time. There is no discussion or consideration of this issue in Deepak Agarwal. So therefore, my lord, this cannot be the ratio of the judgment at all. At best, it would be an obiter, my lord, is the submission.
There is no difficulty here. We agree with you, subject to hearing the other.
No, that's all right. But that's all right. But this is all.
Let us see Vijay Kumar Mishra.
Yes, please see Vijay Kumar Mishra. Vijay Kumar Mishra is at page 87 of this compilation. The fact at page 91, if your lordship will have.
Yes.
I need not spend time reading the facts. I have given your lordships the facts. It's exactly what I have told your lordships. Kindly come to page 93. Actually, I can read from para 3, page 92. Unfortunately, it was neither argued nor did the High Court examine the true meaning and purport of Article 233(2). The appellant's argument before the High Court appears to be that notwithstanding the fact that they are members of the Judicial Service, eligibility for competing for the post of district judge should be considered on the basis of the facts that existed on the cutoff date, and subsequent events are not to be taken into consideration for determining the question whether appellants were barred or not. Then your lordship poses the question. We are afraid that the entire inquiry before the High Court was misdirected. The real question which arises in the case on hand is whether the bar under 233(2) is only for appointment or even for participation in the selection process. Then if your lordship will turn over to 94 para 7, it is page 94 para 7.
Yes.
It is well settled in service law that there is a distinction between selection and appointment. Every person who is successful in the selection process undertaken by the state for purpose of filling up of certain posts under the state does not acquire any right to be appointed automatically. Textually, 233(2) only prohibits the appointment of a person who is already in service of union or state, but not the selection of such a person. The right of such a person to participate in the selection process undertaken by the state for appointment to any post in public service, subject to other rational prescriptions regarding eligibility for participation, etc., and be considered, is guaranteed under Article 14 and 16 of the Constitution. Then at page 321, my lord.
But they also go on a wrong.
Totally contrary.
Correct. So
They say that there is a prohibition.
they proceeded.
Nothing but illusory.
They proceeded on the distinction between selection and appointment.
No. But they say that there is a prohibition for a in-service candidate to be ever.
They say that you can resign.
If there is a prohibition appointment, how can he be eligible?
Just kindly
Person
see,
cannot be appointed and then there is no partner. question of
just
participation.
kindly see page 96, para 14. This is what ultimately the court says. Page 96, para 14.
Yes.
For the aforementioned reason, appeal is allowed. Consequently, writ petition filed by the appellant stands allowed, directing the respondents to permit the appellants to participate in the selection process without insisting upon their resigning from the present employment. If the appellants are found suitable, it is open to the appellants to resign their current employment and opt for the post of district judge if they so choose. So that's the way out. Because, my lord, why this distinction? Because Deepak Agarwal is a bench strength of 3 honorable judges. So therefore, Deepak Agarwal was already there. Para 102 existed. So therefore, to overcome, this is the conclusion which the court comes to. So, my lord, in fact, the submission therefore is, if your lordship will come to my written submissions now.
Yes.
Now, my lord, there is one other aspect I want to point out to your lordships. Kindly have Deepak Agarwal, Dhirajmore, para 19, because that also is a completely incorrect reading of the judgment in Rameshwar. in Chandar Mohan. Please have para 19. Page 123 of the compilation.
It's not there necessarily, is it?
It's SEC. Page 123. The compilation I have given is only SEC.
Okay.
Page 123. My lord, before I read para 19, just two, three submissions I want to make. Chandar Mohan, your lordship have read extensively in the morning. I have quoted those parts. There the word judicial officer was a euphemism for executive officers. 3 times the court says judicial officer is a euphemism for executive officers. In Chandar Mohan, an argument was raised that if the third argument was judicial officer within actual executive officers are not eligible to be appointed in view of the ratio of the law laid down in Rameshwar Tyal. Alternate argument was if they can be appointed, actual judicial officers should also be appointed. Since the first argument was not accepted, second did not arise. While saying so, in Chandar Mohan, the court struck down Rule 14, which allowed judicial officers, in commas, actual executive officers to join the service. Now, in para 19, in Dhirajmore, what the court reads Chandar Mohan to say, that because Rule 14 is struck down by a constitution bench, so therefore all judicial officers are out. This is not a correct reading. Though that judgment never dealt with actual judicial officers. Just see para 19, what is said in para 19, and I'll read my written submission on this. It is apparent from the decision in Chandar Mohan that this.
One minute.
Just see para 19, page 123, para 19. This, I'll show my written submission where I have exactly made this point. Just
Page 120.
page 123, para 19.
Yes.
Just this is how this Chandar Mohan is actually discussed from para 15 onwards in 19. It is apparent from the decision in Chandar Mohan versus State of UP that this court has laid down that concerning district judges recruited directly from the bar, the governor can appoint only advocates recommended by the High Court. And Rule 14, which provided for judicial officers to be appointed as direct recruits, was struck down by this court to be ultra vires.
Totally incorrectly.
Correct. These judicial officer meant executive
Yes.
people. So now just see.
They go on a doctrine of separation of power, independence of judiciary.
Absolutely right.
They said that any person who is though called as a judicial officer, but in effect performing the executive functions cannot be permitted appointed as a district judge.
Absolutely. And see what they say further. Thus, this decision is squarely against the submission espoused by the in-service candidates. This is complete misreading of the judgment in Chandar Mohan. At page 4.
In Dhirajmore.
Misreading of judgment in Chandar Mohan, in Dhirajmore of Chandar Mohan. Correct. In Dhirajmore. This point, my lord, I have made at page 4.
I would learn it, brother.
Yes.
In the above mentioned
In the.
Thus the decision is
Pardon?
in paragraph 19.
Yes. Thus, yes. Thus yes, that's what I want. Thus, the decision is squarely against the submission espoused on behalf of the in-service candidates.
Go further down.
All right. In the above mentioned para 11 of Chandar Mohan, the position is made clear. In Chandar Mohan, the court held that only advocates can be appointed as direct recruits. And inter alia Rule 14, providing for executive officers recruitment, was struck down.
Rule 14 is for executive officers recruitment.
Correct.
They notice it.
They notice it and yet say that judicial officer is struck down. Correct. This court held that the expression service of state or union means judicial service. It only refers to source of recruitment. Dichotomy of two sources has been called out in this decision. This is complete misreading of the judgment, Lord. Complete. And my lord, if your lordship also
doing violence of the finding.
correct. Now, kindly also now come to para 13 and 14. because there is one more proposition called out in these paras, which I feel is not correct, my lord, at page 116. Here, they have, here, para 13 and 14 is the first time after noticing facts the court discusses. Now, kindly come to placetum F at para 13, page 116.
How do they consider Rameshwar?
Consider Rameshwar.
Rameshwar Dayal?
Yes,
I think
Rameshwar, my lord, is considered in para 20 onwards. Para 20 onwards and para 21, if your lordship will see what is said, I was going to come to that after this. If your lordship will see para 21. After noticing Rameshwar, Rameshwar is quoted in para 20 extensively. Then para 21 at page 126. It says, much was tried to be made based on the facts of Harbans Singh and P.R. Sani in the decision of Rameshwar Dayal. Now, your lordship has seen those facts. In fact, P.R. Sani was a chairman of the Improvement Trust.
Both of them were government officers.
No, one more fact. P.R. Sani was chairman of the Improvement Trust. His license to practice was suspended on that day. Yet the court holds, because they were advocates, they continue to be advocates and have declared them to be eligible. In spite of that, my lord, at page 127, after noticing, the extract is there, then after noticing, two of them were not in judicial service as on the date of their appointment. They had practiced earlier for the requisite period as advocates, later were appointed as district and session judge. Harbans Singh was working as deputy custodian evacuee property when he was appointed as district and session judge. In 58, he was appointed additional judge. At the relevant time when appointments were made, recruitments were permissible from executive service too. That's correct. Their eligibility to be appointed was tested. The question which came up for consideration was not whether they could have been appointed being in service of custodian of evacuee property or improvement trust. What was held by this court concerning interpretation of Article 233 in the above mentioned para 12 by a constitution bench goes squarely against the submission raised by the in-service candidates is something which is not really borne out from these paras at all.
So their eligibility to be appointed as Legislature was tested. The question which came up for consideration was not whether they could have been appointed being in service of the.
This is not correct. This was
or the Improvement Trust.
there was a direct
As a matter of fact, they were holding that those posts.
correct. There was a direct challenge to their appointment, which challenge was repelled and their appointment was affirmed. Of course, they had in the meantime been appointed, and two of them were holding were judges of the High Court at that time, when by the time this case got decided. Now, one more fact I want to point out. In paras 13 and 14, the requirement of 7 years has been married to the condition of not being in judicial service. If your lordship will see 13 and 14 at page 116, this also does not flow from 233. If your lordship will just see para 13 and 14. Para 13. All right. My learned friend says first line, para 13 at page 116. Article 2, your lord, my lord, sir.
Yes, page?
Page is, my lord, 116.
Yes. Yes. Yes.
Article 233(2) starts with a negative stipulation that a person who is not already in the service of the union or the state shall be eligible only to be appointed as district judge if he has been an advocate or pleader for not less than 7 years, is recommended by the High Court for appointment. Lord, I am running out of time. Just kindly come to placetum F. Requirement of 7 years experience as an advocate is qualified with a rider that he should not be in the service of the union or state is not a correct interpretation at all, my lord. This is carried forward again in para 14, second line, first two lines. Article 233(2) provides if an advocate or pleader has to be appointed, he must have completed 7 years of service. It is
Where are you reading?
para 14, first two lines. Article 233(2) provides if an advocate or a pleader has to be appointed, he must have completed 7 years of practice. It is coupled with the opening part that the person should not be in service. There is no, with great respect, my lord, there is no such marriage or coupling in the provision.
And what does this to do with Article 50? They have reproduced Article 50.
Correct. And
The separation of judiciary
correct,
from executive.
correct. The person in service once he has. So, my lord, this is regarding Dhirajmore, my lord. In my written submission, my lord, I have actually dealt with the correct interpretation of has been. Just kindly allow me to read to your lordships one part of it. The other is all judgments. Your lordship will see, my lord, I have quoted all those judgments. But just come to page 14 of the written submission. Something very interesting. Page 4591, something very interesting. In Dhirajmore, the Hindi translation of Article 233 is reproduced.
4-5?
4591 is the written submission. Your lordship has my written submission hard copy. Just kindly see, type page 14 at the top. Or in, just 1 minute. All right, page 4591, my learned friend says. 4591. Oh, there is an internal page here. Okay.
It's in para 7.
Now, para 7 of the submission, my lord. The review petitioners also seek to rely on the Hindi and Punjabi version of article. Your lordship got this line, my lord?
Yes.
Of Article 233 of the Constitution. The Hindi version of the Constitution has been quoted in paragraph 7 of the judgment in Dhirajmore. A reading of the same would show that the expression used is pleader raha hai. In Hindi, it says pleader raha hai. It is submitted that the expression is raha hai and not hai. Therefore, the term raha hai denotes a past state of affairs and not a present one, and is not necessarily continuing in the present. As noted in para 9 of Dhirajmore, the Hindi translation of the Constitution was signed by the members of the Constituent Assembly and therefore must be treated as an authoritative text. Now, the next is, my lord, what we have got from the petitioners have also got Punjabi translation of this article from the website of the Legislative Department. The expression used in the translation is reh chukya hove. Reh chukya hove is clearly past tense. So therefore, my lord, if your lordship agrees with what my learned friend Mr. Jayant Bhushan is saying and answers question 4 in our favor, nothing of this will arise. Assuming your lordship does not, then also I say, for a person like me who has 7 years service, who has joined and then is willing to resign his assignment, his service, and join as a fresh recruit, merely because I have been joined, should not be held to be a disqualification for my even being allowed to compete for the post. I am very grateful, my lord. I have tried to make the written submission comprehensive the way I want to project it before your lordships.
Thank you.
Very great.
May it please you, Lord. Lord, the item number is 501.15. His name is Dhirajmore.
You are Dhirajmore.
I'm Dhirajmore.
Yes, sir.
Your item number is
501.15.
15.
Yes,
Okay, just a minute.
yes. May please.
Can I be excused only for 5 minutes? 5 minutes, if I can. For 5 minutes, if I can be excused.
No, we are not stopping anyone to. We have been seeing Mr. Shankar Narayan is sometimes chair, sometimes the central chair is vacant. Yes, his presence and absence both are conspicuous.
Yes. Yes, please.
My lord, petitioner was enrolled as an advocate on 3/8/2000, only two, just as, and then he became a
Enrolled on
3/8/2000,
I think 12 years of experience.
and then my lord, he became an assistant public prosecutor on 2/4/2006.
on
2/4/2006. And then, my lord, on 2/4/2008, he joined the Haryana Judicial Service. And then, my lords, on 8/9/2009, he joined the Delhi Judicial Service. He had more than
On?
7.5. He had 7.5.
no, when did he join Delhi?
Delhi, my lord, on 8/9/2009. That continued, my lord, and thereafter he applied for direct selection as district judge, and then ultimately the matter reached this honorable court, where this honorable court held, my lord, in Dhirajmore, that he was not continuing as an advocate on the date of a selection or even application or appointment, and therefore, my lord, he is ineligible. This is the sum and substance of. He therefore had 7.5 years of service in the bar, my lord, when he had before he joined the judicial service also. But my lords, since your lordship, sorry,
If you include the APP's practice, then he had 7.
yes, including, only if that is included. Your lordships are right. Yes. If your lordships are considering issue number 4 on a broad spectrum basis, and then your lordships are pleased to answer it on the ground affirmatively, then, my lord, none of the other questions may really arise. And therefore, my lord, the question is, what is it that your lordships would be considering in question number 4? No, my lord, in my respectful submission, my lord, Dhirajmore may be erroneous, my lord, on 2 or 3 broad grounds. Firstly, my lord, to say that there is a 233(2), Article 233(2) provides for a quota for advocates, my lord, insofar as appointment to the post of district judge is concerned. 233(2) doesn't provide any. My lord, that's a reading of the constitutional provision, which, my lord, in my respectful submission, may not appeal to your lordships. There is no quota that is contemplated here. My lord, 233 as a whole has been held to be a self-contained court, my lord, in the earlier constitutional bench judgments of this honorable. More particularly, Rameshwar Dayal. Rameshwar Dayal, my lord, specifically and pointedly considered the question as to whether an applicant to the post of a district judge under 233 is required to be an advocate or a pleader on the date on which, my lord, he applies for it, and the date on which he is selected, and finds that he need not be. Rameshwar Dayal, my lord, holds against, lays down a dictum which does not mix up the two. Rameshwar Dayal, my lord, considers the appointment of both Harbans Singh and Sawhney, who were not on the rolls of the Bar Council, my lord, on the date of selection on the date of appointment as a district judge, does not find them ineligible, my lord, to be considered. And therefore, my lord, upholds the appointment on a specific basis. The law dictum laid down by Rameshwar Dayal in that instance, Chandramohan comes about subsequently on the essentially dealing with the question as to whether the service which are rendered by executive magistrates could also be treated as judicial service for the purpose of Article 233, holds affirmatively that it can be. But Rameshwar Dayal, my lord, which is a constitution bench judgment, specifically considers this question as to whether persons who are in judicial service on the date of appointment, date of selection to the post of district judge, which is a selection under 233 specifically, can take note of the fact that they have been advocates, can rely on the strength of the service which they had rendered as advocates and hold that they can. It is in the context of a direct recruitment under 233. My lord, Rameshwar Dayal has been misconstrued, my lord, in my respectful submission, both in Dhirajmore and also in Satyanarayan Singh, my lord, which is also a 3 judges bench judgment. And how they, my lord, it has been misconstrued, if I may say so with respect, is to take, my lord, that these are two disparate streams. Advocates in one stream, persons in judicial service in the other stream. And therefore, at no point of time can they be permitted to mix together or jump from one stream to the other. This is a graphic manner in which, my lord, Satyanarayan Singh has been, has expressed it. And Satyanarayan Singh, my lord, has been specifically referred to in Dhirajmore in paragraph 21 onwards and has been followed in that behalf. And ultimately, it is that which is laid down as a dictum, my lord, in paragraph 45. My lord, in my respectful submission, neither the wording of Article 233 nor, my lord, Rameshwar Dayal can be considered as in any manner, my lord, persuading a bench which came thereafter to take a view to the effect that these are disparate streams and therefore, my lord, a person in judicial service, though was preceded by the service as an advocate, whatever be the tenure of service, my lord, that's a different matter that arises in the context of question number 4. They should not be permitted to apply for a post of the district judge on the basis of a direct recruitment under 233. That in sum and substance, my lord, is a question which frontally arises for your lordship's consideration. If your lordships are pleased to hold that Rameshwar Dayal has construed it correctly, and that is in sync with your lordship's own reading of the constitutional provisions as such, then, my lord,
Dayal, if you rely on Rameshwar Dayal, then even the executive would be entitled to compete.
No, that, my lord, Chandramohan takes.
Therefore, you may rely on Chandramohan because.
No, my lord, I relied on Rameshwar Dayal essentially for saying that Rameshwar Dayal, my lord, is sought to be distinguished, my lord, in Dhirajmore, and in my respectful submission, Chandramohan and Rameshwar Dayal are read in tandem, and ultimately, my lord, in Dhirajmore,
On the contrary, Dhirajmore told that Rameshwar Dayal and Chandramohan, they reject the condition raised on behalf of you.
Wrongly.
Wrongly, yes, therefore.
Okay. That's correct. That is not how, my lord, Rameshwar Dayal or Chandramohan read. But Dhirajmore, yes, says that this is what Rameshwar Dayal held, this is what Chandramohan.
That has been argued by.
Yes.
It is also that the finding of Dhirajmore.
Yes.
With regard to Rameshwar Dayal.
Yes.
And Chandramohan.
Yes.
Is not correct.
Yes. No, my lord, please have a look at Rameshwar Dayal once more. Manner in which, my lord, this question as to whether he should continue in service, whether he should continue as an advocate on the date of his application or selection. What is a finding? It was a frontal question. It is not an objective. Specific question that is raised.
Both of them were already in service on the date on which they were appointed as district judge.
Yes. My lord, my submissions are restricted, my lord, only to this. Other things have been covered, my lord, and therefore I don't want to take up your lordship's time. Please come to Rameshwar Dayal once. And please come to the manner in which, my lord, Dhirajmore is misconstrued it, if I may say so with respect. My lord, could your lordships kindly go to the volume which Mr. Patwalia had handed over?
No, don't go to that because it is SCC online.
Very well. Very well.
We were reading the SCR.
My lord, volume 1, page 98 of the compilation.
The second volume.
5-1.
Yeah. volume 5. Point, इसमें का second volume.
Well, Lord, if your lordships are going by the pagination, at the middle of the page, it is, please come to page 104, because this starts at page 98.
Bhushan, Dhirajmore is in volume.
Not Dhirajmore, my lord.
So, sir,
Rameshwar.
Rameshwar Singh is volume.
5.1. 5.1. My lord, if your lordships would straightaway come to page 104, because the paragraphs are not numbered, I go by the pagination, my lord, 104 at the middle of the page, the fresh paragraph starting therein. This is where, my lord, the court had my lord, focused on the issue. It would thus appear that of the 5 respondents mentioned above 3, namely Shamsher Bahadur, Gurudev Singh and Hansraj Khanna had their names on the roll of advocates of the Punjab High Court before they were appointed as district judges. In other words, they were practicing as advocates at the time they were so appointed. 2 of them, and this is where, my lord, the issue frontally came up for consideration. Harbans Singh and P.R. Sawhney did not have their names factually on the roll when they were appointed as district judges. P.R. Sawhney, it appears, had his name so enrolled on 20th of October 1959, that is after his appointment as district judge. We are inviting to this distinction amongst the respondents at this stage, because as will appear later, this distinction has some bearing on one of the arguments made before us on behalf of the appellant. Now, my lords, the next page, or the same page, my lord, the last paragraph. Now, the argument that the learned counsel for the appellant is ranged over a wide field, but the point for decision is a narrow one and depends on whether respondents 2 to 6 fulfill the requirements of clause 2 of Article 233 of the Constitution when they were appointed as district judges by R1. That clause lays down that a person not already in the service of the union or the state shall only be eligible to be appointed a district judge if 1, he has been for not less than 7 years an advocate or a pleader, and 2, is recommended by the High Court for appointment. As to the second requirement, no question arises here, because admittedly 2 to 6 were recommended by the High Court for their appointment. Then, my lords, please come down, and then a sentence which starts in the same paragraph. Secondly, that is after the Legal Practitioners Act is referred to. Secondly, he has submitted that by reason of the use of the present perfect tense has been, in clause 2 of Article 233, the rules of the grammar require that the person eligible for appointment must not only have been an advocate or pleader before, but must be an advocate or pleader at the time he is appointed to the office of the district judge. Therefore, this is a pointed issue. Yes. Now, after this, my lord, if your lordships kindly come to page 110 in the middle, the paragraph which starts there, the fresh paragraph starting therein, and towards the middle of that, after Article 124 and 217 are referred to, and this is where, my lord, the court says, and this is a much quoted provision, statement, Article 233, if your lordships have got it. Article 233 is a self-contained provision regarding the...
You are at 107.
My lord, 110, my lord, 110. Fresh paragraph starting at 110.
110.
That starts with the word learned counsel for the appellant. My lord, I'm skipping some of them. And then if your lordships come about 10 lines below that, the sentence starts with Article 233 is a self-contained provision.
That we have already read.
Yes. I just give me 1 minute, my lord, so that I can complete my submission.
On the contrary, when Mr. Bhushan was arguing,
Sorry. Yes. Mr. Patwali was arguing.
no, when Mr. Bhushan opened the argument,
Yes, yes.
we said that this directly reaches the point.
Yes, my lord. No, my lord. When your lordships kindly come to page 112, last line, why I keep inviting your lordship's attention to this is that this is a ratio and this has been completely misconstrued, if I may say so, with great respect. When it comes to Dhirajmore, the last line at page 112.
It specifically says that if a person is in service of the union or state, no qualification is required. The qualification is required if he is not in the service and if he is an advocate, then that 7 years embargo is required.
That's correct. But to say that therefore, if you are applying as an advocate, the fact that you have been in service disentitles you to apply for the post because you are not an advocate on the date of the service, on the date of the application, is what ultimately my Lord Dhirajmore comes to. That is nowhere my Lord
Bank of
mentioned.
BJP, we find that Dhirajmore does not correctly consider both Ravi
That's right.
and
That's right.
Chandrababu.
That's right. On this crucial aspect as to my Lord present tense, present past tense.
Both the judgments have been misread.
Yes. Both Dhirajmore and Satyanarayan Singh, my Lord, which is also part of this.
Around the chief justice pointed out,
Yes.
paragraph 110, which I think he wanted you to see.
Page 110. Yes.
Settles the issue now. It says, subsection 2 of 233 deals with only lawyers and lawyers have the qualification.
That's right.
231 is common, no qualification is prescribed. That's the only thing.
And,
If somebody has understood Rameshwar, there's no difficulty at all. And then subsequent judgment also someone rightly understood to mean with respect to service.
Chandrababu also says that
He said,
same thing, but only says that when you are appointing a person from a service, he shall be only from the judicial service.
Yes.
that's correct.
That
Because it draws a distinction to the earlier service where they, from the civil service also somebody has been taken.
Yes.
No, they clarified it. Because
You know, in 1985, there was a watershed.
your side can conclude today.
Sorry, my Lord? Yes, yes.
Your
I
side
don't know.
can conclude today.
I don't know, my Lord. See. My Lord, I'll take another 10 minutes. I'll stay within my allocated time. I won't go beyond that.
But fortunately, so far, everybody has been keeping the time.
pointed, no.
No, we'll do that, my Lord. I think all of us will do that. Unless, my Lord, there is some issue which arises on which your Lordships would require assistance. My Lord, in which case, my Lord, we may have to assist your Lordships with some extra allocated time. But apart from that, my Lord, I'll. My Lord, there is one factor, my Lord, which seems to have escaped the notice of. My Lord, there are certain principles which flow out of Rameshwar Dayal and flow out of the reading, my Lord, a plain reading of Article 233. My Lord, persons in the service, persons not in the service, and therefore advocates have to have 7 years of service. Persons in the service coming under 233, 1 or 2 or whatever it is, my Lord, there is a constitutional provision which enables that such persons in service can also be considered for direct district judges. My Lord, 233 speaks about district judges and the manner in which, my Lord, the appointments will have to be made. When it comes to other posts, my Lord, in the subordinate service, the wording is different. It comes completely under the control of the High Court in accordance with the rules that are framed, my Lord, under 3 by the governor in consultation with the High Court. What your Lordships have held, and that also, my Lord, in a constitution bench judgment of Bal Mukund Shah, that when it comes to appointment both to the post of district judges and other services, my Lord, in the subordinate service, consultation with the High Court, my Lord, is mandatory. It cannot be otherwise. Even a paramount plenary legislation, my Lord, in Bihar was found to be, my Lord, not valid because the question of requirement of a consultation with the High Court was not satisfied. Point is this, my Lord. Therefore, a constitutional provision, which is, sorry.
What we are trying to understand, what you are saying is right.
Yes.
Now, if you understand the scheme,
Yes.
as we understand it,
Yes.
it puts the judicial officer at the higher pedestal.
Yes.
That's the reason why.
Yes.
That is the reason why it did not prescribe any qualification, number 1.
Yes.
Number 2,
Yes.
it has given to the respective High Court to frame the rules.
Correct.
On the contrary, as a lawyer, whoever is to be qualified, it has been mentioned under the Constitution.
That's right.
So
No.
233(1) is meant for everybody.
That's right.
Who's to appoint, how to appoint. These are the general things, right, about the power and the manner which it can. That is again, when you have rightly said, Your Honor, in consultation with the High Court means High Court can frame the rules, which again, he was also saying that maybe he doesn't have an objection with respect to the number of years to be fixed. That is one part. The other part is with respect to the qualification with a specific reference to the lawyers.
That's right.
Therefore,
My lord, no, I was just,
understand subject to hearing term.
though I am not strictly concerned with question number 4 because I don't require the benefit of a broken service being mixed. Because I already have 7 years of service, as my lord the Chief just pointed out,
Once we
as an
hold,
APP.
once you will hold the constitutional, the wisdom of the constitutional mandate is there,
Yes,
by placing it on a higher pedestal.
that's correct.
Because you know, when somebody is working as
Then it is a
role as a
logical.
lawyer,
Correct. Your lordship
somebody
are
is
right.
working as judicial
That's
officer,
right. That's right.
you will see the experience will.
That's right.
go.
That's right.
So
And-
therefore, they consciously left it open to the High Court. How do you regulate it?
That's right. That's right. And therefore, my lord, there is a
Constitutional.
constitutional.
To go into all these things.
There is a constitutional justification if your lordships come to the conclusion that in assessing the 7 years, 4 years or 5 years in the bar, and the remaining service may not in the judicial service could be tagged along to consider whether the eligibility conditions are satisfied as such. There's a justification for this. Because your lordships are holding, and rightly so, if I may say so with respect, that the judicial service will have to be put on a pedestal which is higher than that, the service which you render in the bar.
In our little experience, we can tell you, just excluding the senior lawyers, I would say my law clerks is that 1 year of judgeship is equal to 5 years of being an advocate. In terms of sheer experience,
Oh yes.
the volume of work
Oh
what
yes.
you get
Oh yes. Oh yes.
for everybody, I'm saying.
Oh yes.
So, that is the reason why they consciously left it
Oh
open.
yes. Oh yes.
Then, as rightly said, there is no reservation here. You can't interpret it like this. 233 and 33(1), it speaks about persons.
And what you
When
want,
you see 233(2), it
Correct.
speaks about person.
that's
It's
right.
in one category.
That's right.
It speaks about A category,
That's
while subsection 1 speaks about all categories.
That's right. That's right.
So this-
And-
that's
and- and-
difficulty on this.
And therefore, my lord, when your lordships are actually putting that meaning, or lordships are infusing that constitutional justification on a reading of Article 233(2), your lordships are essentially culling out the meat of the matter and then putting it across. Saying what? This is what 7 years is required. But 7 years, how to compute the 7 years is a matter in which your lordships will have to consider whether the nature of the service that is rendered. In fact, the distinction between somebody serves for 5 years, then goes, and then serves in some other capacity. Your lordships rightly say no, because there is a complete disconnect. And that cannot be taken note of, my lord. It may be a hard case. Then he comes back after 3 years, serves for another 3 years, still doesn't complete 7 years, and then goes. But then, my lord, your lordships will not take that into account and then say he enrolled, he got himself enrolled some 15 years or 20 years ago. And therefore, his total service will have to be considered. Your lordships will not accept it. Why? Because it is a completely dissociated service. But why your lordships at the same time would accept a case where he has been in judicial service and therefore tag along the service which he has rendered for the purpose of considering whether this is eligibility under 233(2). Your lordships will take note of the fact that the service which he renders is in the same category. The spectrum is the same. That could be the constitutional justification. My lord, coming back to what Dhirajmore has held, just come to paragraph 45 alone, my lord. That's the conclusions, 47. And this is where, my lord, we would respectfully submit that your lordships may have to
That has been read to us.
pointedly overrule. Sorry,
Para 47 has been read to us.
yeah, it has been read. Dhirajmore, and you're taking something, reading something else.
Both para 47 of Justice Mishra's judgment as well as the judgment of Justice Bhatt.
That's right. That's right. Those do not lay down the law correctly, my lord, in my most respectful submission. Starting from paragraph 45. Yes, volume, Dhirajmore, if your lordships have it. We answer the references under the members of the judicial service of the state can be appointed as district judges by way of promotion or limited competitive examination. Fair enough. The governor of the state is the authority for the purpose of appointment, promotion, posting, and transfer. The eligibility is governed by the rules framed under 234 and 235. Fair enough. Under 232, an advocate or a pleader with 7 years can be appointed as district judge by way of direct recruitment in case he is not already in the judicial service of the union or a state. Obfuscates the service which he had rendered as an advocate prior to him entering into the service. And to that extent, therefore, my lord, what is mentioned in 4 also, for the purpose of Article 233(2), an advocate has to be continuing in practice for not less than 7 years as on the cutoff date and at the time of appointment as a district judge, which also, my lord, takes it beyond the date on which the selection itself is considered. Members of the judicial service having 7 years experience of practice before they have joined the service or having combined experience of 7 years as lawyer and member of the district are not eligible to apply for direct recruitment as a district judge. My lord, these 3 or 4 principles, my lord, culled out in paragraph 47 in our respectful submission, my lord, lordships may have to reconsider. The rules framed by the High Court prohibiting judicial service officers from staking claim to the post of district judge, again suppose reserved for advocates. The euphemism of what is stated as post reserved for advocates, where is anything reserved for advocates, my lord? By way of direct recruitment cannot be said to be ultra-vires and are in conformity with Articles 14, 16 and 233 of the Constitution of India. My lord, I am not really concerned with the virus of the rules, my lord, in the Delhi Judicial Service because that doesn't contain this prohibition. At any rate, my lord, I don't fall within that.
It doesn't contain such a provision.
I think only 2 high courts contain this. And therefore, my lord, but since your lordships are considering it on a broad spectrum basis, such rules, my lord, if they contain a prohibition, may not stand the test of Article 14 and 16. Firstly, for the reason that advocates do not have a quota. Secondly, when you are considering direct recruitment to a public service, and therefore 14 and 16 straight away apply. My lord, the rest of the things have been argued. My lord, I'm grateful to your lordships.
Yes, madam.
May I just request your lordships to take up Dhirajmore and just the Hindi part? Because your lordship,
Para 7.
para 7, your lordships. Your lordships will see the placing of the comma in Hindi, which makes it very clear that Rameshwar Dayal interpretation is the correct interpretation. Page 971, your lordships. Lordships, page 970 is the English and 971 is the Hindi. And we had placed this before the 3-judge bench also, your lordships. And your lordships will see subclause 2. It says, वह व्यक्ति जो संघ की या राज्य की सेवा में पहले से नहीं है, जिला न्यायाधीश नियुक्त होने के लिए केवल तभी पात्र होगा जब वो कम से कम 7 वर्ष तक अधिवक्ता या प्लीडर रहा हो और उसकी नियुक्ति के लिए उच्च न्यायालय में सिफारिश की है. So the only mandate in this is that anybody who doesn't belong to the judicial service as interpreted in Chandra Mohan, your lordships, will compulsorily require 7 years. As far as the judicial service is concerned, your lordships, the 309 rules which are prescribed by the High Court will apply because that itself has to be an advocate, has to take an exam and so on and so forth. So 233(1) prescribes the rules which the High Courts will set out, your lordships. And thereafter, your lordships, if a person is ordinarily not coming through the judicial service process, your lordships, has to minimum have an advocate's qualification and practice as 7 years. So that is the import of 233, your lordships. As
That's what Rameshwar Dayal.
that's what Rameshwar. And
Qualification is not provided for in-service candidates. Qualification is
Absolutely.
provided only for lawyers.
Grateful, your lordships. Now, your lordships, I just wanted to bring to your lordships notice that if the provision is interpreted the way it has been interpreted in Dhirajmore, what is the grave damage that is being caused to the entire judiciary, your lordships? Because I have just collated some data and some facts and figures, your lordships, to bring to your lordships notice that the violence to this principle, your lordships, will lead to a lot of problems, including there will no appointments on time, because Malik Mazhar provides that every year there has to be an appointment cycle, your lordships. Vacancies fall very, very short, and I'm not placing this without any evidence, your lordships. When the advocates category comes, then your lordships, the number of persons who are selected are far shorter than the number of persons that are required against the vacant posts. And those vacant posts, if carried forward, your lordships, then lead to further inefficiencies, and if they can't be filled, your lordships, then those vacant posts remain. Your lordships may kindly just take for a moment
All right, see, we are on the eligibility now.
Yes, your
What you
lordship.
say is, I think it's a fact because take it from us, we are far more experienced in that because we
Absolutely,
also
your lordships.
have been part of it at different parts of
Yes,
time.
your lordships.
But we are on a different larger
So
scale.
your lordships, what I'm saying is that if the language is to be read the way Dhirajmore has read it, then it doesn't take care of also of the fact when the quota breaks down, because the quota is a creation of all India judges. It's not a constitutional
That's
creation.
what my learned brother has been saying.
Yes, your lordships. The quota is not created by Article 233. Unfortunately, in Dhirajmore, it has been read to be created by 233, your lordships. That is the first point, your lordships. The second point, your lordships, some paras of Dhirajmore where the error is absolutely apparent, besides 45 and 47, your lordships may kindly come to para 13 at page 972. And I'm just extracting the grave errors.
Para
Para 13, your lordships,
of the Dhirajmore.
of Dhirajmore, page 972 SCR.
We are having the SEC
The paragraph number is the same, your lordships, paragraph 13.
begins with Article 233 too.
Yes, your lordships, negative stipulation. Your lordships, the very first
But
sentence.
we have already read.
Yes.
Para.
What I'm pointing out, your lordships, is the last three lines, which is glaring error, which your lordships will probably put in inverted commas. Article 233(2) nowhere provides eligibility of in-service candidates or consideration as district judges concerning a post requiring 7 years practice as an advocate or a pleader. Requirement of 7 years experience for advocate or pleader is qualified with the rider that he should not be in service of union or of state. This qualification, your lordships, is read into 233. So three things have been read into 233 by Dhirajmore, your lordships. One is that judicial officers are excluded from consideration for the post. Secondly, your lordships, what has also been read into this is that the judicial service people cannot be considered for the post. So all these things have been read in. The other thing that has been read in, your lordships, has been in practice. So the cutoff date on which he must be an advocate, that is in para 14, your lordships. In fact, in para 13 itself, if your lordship just sees above Article 50 quotation, it also talks about that thus it is clear that the members of judicial service alone are eligible for appointment as against post of district judge, as the only mode provided for appointment of in-service candidates is by way of promotion. So LCE also in a way is given a go by. Your lordships, it says only by promotion, because LCE also is not just a time bound promotion. There is an
I didn't get your submission.
Your lordships will see in the middle of this paragraph. What I'm saying is these
No, para 13.
para 13 towards almost the end of it, your lordships, just about half a para before Article 50.
The requirement of 7 years experience.
Your lordships, where it says there are two separate streams provided. Your lordships had read this part.
Just
Article-
G in the SCC. There are
Yes.
two
So
separate.
there are two separate.
Yes, your lordships. Now, all this is read into 233. Article 233 provides two sources of recruitment, one from judicial service and the other from advocates or pleaders. These are two separate streams provided. One is for persons in judicial service and the other is for those not in the judicial service of union or state and have practiced for 7 years. So it makes a clear chasm between the two. The expression in service of the union or the state has been interpreted in Chandramohan to mean judicial service, not any other service of union or state. So far, so good, your lordships. Now, your lordships, this sentence. Thus, it is clear that the members of the judicial service alone are eligible for appointment as against the post of district judge, as the only mode provided for appointment in service candidates is by way of promotion. Your lordships, this is absolutely incorrect and has to be reviewed, your lordships. then your lordships will kindly see.
Thus, it is clear that the members of the judicial service alone
Yes,
are eligible for appointment as against the post of district judge.
district judge, as the only mode provided for appointment of in-service candidates is by way of promotion. There is no such bar under 233. 233 doesn't say that judicial officers cannot compete for certain number of posts of district judges. No such parameter is set in 233. These are some parameters which some high courts made as rules and said that we will have first quota used to be 50-50, your lordships, then lordships revised it to bring in the LC process, your lordships, to make it competitive.
It is saying is that's correct. What is provided,
Yes, your lordships.
that they want. One channel is only meant for judicial officers.
Yes, your lordship.
That's correct.
Yes,
But you are right. The other channels also is like an open category.
please, your lordships. That's,
Now, what Deepak More says is that one channel is for judicial officer, other channel is.
there's a complete separation which is in.
But one channel is for judicial officer is correct because nobody else can participate there. It's only a way of promotion. Whether merit seniority or seniority come merit, it's a subject to that. That's a different issue.
Because the argument that is raised from the other side is that if the advocates have a pure 25% quota, in fact, their entire emphasis is on quota. So they say if there is a 25% quota, then nobody can fluidly move into this. Whereas the rules provide, and in fact, if there are leftover vacancies, I have just made an examination, your lordships, about 4 to 5 states, and I'll just take your lordship's patience a little bit to show in Madhya Pradesh, your lordships, after the Chief Justice's conference in 2015, when this entire problem was discussed.
You are giving this statistics to the Chief Justice of India. He knows everything. We know that's we don't want to express it. We know what's the
We are at a public forum here, so we have to place it, your lordships,
Very well.
for everyone's benefit. So, your lordships, 2015, the Chief Justice's meeting takes place, in which it is deliberated and decided that every high court, depending on the caliber of its district judges or the lawyers, your lordships, will decide as to how to have the best merit, your lordships. So, in Madhya Pradesh, your lordships may kindly take this volume 6A for a moment.
Tell us orally, we will not, because
That's not right.
I'll tell.
while interpreting
Yes,
the
Lord.
constitutional
I'll-
provisions, we did not go on the data.
Yes, yes. So your lordships will see that Madhya
And
Pradesh.
each one of us,
Yes, your lordships.
coincidentally, there is no member directly from the VAR here on the bench.
Yes, your lordship.
Everybody has had experience in his own high court.
Yes, your-
And some of us in more than one high court.
Because lordships are very aware of the rules.
Yeah. Therefore, on the concern expressed by you, see, we agree with you.
Yes, your lordship.
That's a
Yes.
real serious problem.
So your lordships, what I'm driving to your lordships is that many high courts, especially Madhya Pradesh High Court, provides that when quota breaks down, when for 2 consecutive years you cannot find any suitable advocate, because your lordships, the figures are dismal. 1 out of 16 people are selected in the advocates category, your lordships. When it breaks down, and the breakdown point is also decided after 2 years. When it breaks down, then how do we fill these?
Let us not go into those.
Your lordships. So if the eligibility itself is knocked off of these judicial members, your lordships, the efficiency of the service is at stake. That is the point I'm making.
Shetty Commission has already elaborately considered that, and we
Yes, your lordships.
have seen the report of the Shetty Commission.
Very well. Now, your lordships, one more point I wanted to make is para 33 of Dhirajmore, is where it very cursorily rejects our argument on Article 14 and 16, which is the deprivation of opportunity. Paragraph 33, your lordships. Because your lordships, if 233 does not provide a bar, if I have the qualifications, then I definitely have a right.
You not tell us, you are appealing for whom?
Your lordships, I'm appearing for the category of people who were advocates for 7 years, and thereafter they sat for the judicial exams and got selected, and then they again sat for this selection, your lordships, in the advocates category.
Yes, serial number?
21, 501.21. Netrapal, your lordships, UP judicial officers. And the challenge had come, your lordships, with the rules which provided a bar. So the challenge to the rules have come from both sides, because some rules provided the fluidity of shifting and migrating, your lordships. But many high courts said that there is a clear bar and you cannot shift or move on to the other category. Lordships, just one line in paragraph 33, if I can read. It was submitted that promotion is no substitute for direct recruitment, as against the post reserved for direct recruitment, an incumbent can apply throughout India, whereas an in-service candidate can be promoted within the state. And there is no definite period for coming into the zone of consideration for promotion in higher judicial service. Thus, it was urged that direct recruitment is altogether different from promotion, and having practiced for 7 years, they have basic eligibility to stake their claim for the post reserves for advocates, pleaders, and they have additional experience of acting as a judge too. We find no room to accept these submissions. And the next line, your lordships, is what I have objection to. Once the Constitution envisages separate sources of recruitment, no case can be made out of deprivation of the opportunity. Once service is joined, one has to go by the service rules, and it was open to such an incumbent to practice and stake claim in various states while remaining in practice. It is a matter of two different streams of recruitment which is permissible. Such an argument cannot be accepted.
Okay.
The other aspect, your lordships, which I will not cite, your lordships, but I've put in the compilations, is with regard to the pragmatism of the interpretation of constitutional provision. And just one figure, your lordships, that we have only 21 judges to every 10 lakh people, your lordships. That being the situation, lordships are always at pains that even one vacancy should not be left, your lordships. Given that aspect, your lordships, if there is a bar which is read into a provision, your lordships, it's going to be very, very against the judicial efficiency, your lordships. I'm very grateful.
May it please your lordship, my lord, I appear for the state of Kerala in the first case of Rajneesh versus Deepa. My lord, Mr. Naidu is appearing for Rajneesh. So, my lord, I will not take too much time on the facts. My lord, we all have a restriction of time. So, my lord, I'll leave it to him, my lord, to give you, go into
You have
details.
time. You have to begin at 3:45, you are beginning at 3:30.
Yes, my lord. My lord, we have taken your lordship's injunction very seriously.
Sir, she has given you 15 more minutes.
No, my lord, I'll try to conclude in 15 minutes. My lord.
No, Vibha Datta Makia ma'am, she was allotted half an hour.
Lordship.
She concluded in 15 minutes. So you have 15 more minutes. Or Dr. Singhvi can begin today after you. Yes, brevity of words.
We appreciate that.
My lord, whatever your lordship says, my lord, I am prepared to.
Lord Coke. Lord take little delight from garnish of words and garnish of flowers.
My lord, actually, my lord, the theory that councils should be allowed to continue at length is not correct, my lord. The very same councils before your lordship, when they appear in international arbitrations, are given very definite time slots, and they very happily, my lord, fit into that. If your lordships were to insist on it, my lord, I believe, my lord, there will be no difficulty, my lord, on our side.
But even in the last constitution pages, we except only 2 hours were extra. Otherwise, we finished within the time schedule.
Yes.
And this we think that we have unnecessarily granted more time.
Correct.
We could have concluded within 2 days.
Sometimes it's not more time. Problem is how to last during the time which your lordships have. If questions come from all your lordships, the question is how far are we going to survey for this half an hour?
Especially when your lordships view already falls, your lordships, then there is not much for us to say.
That's always difficult for the third or fourth council. When you start can take his own time. So. Yes, please.
You are 50.1.
Yes. Rajneesh versus K. Deepa, and the respondents will not include the state of Kerala. Now, Rajneesh was a person, I will summarize, my lord, the fact in one sentence. There are details, of course, my lord, which the counsel for Mr. Rajneesh can give your lordship, my lord. Rajneesh, my lord, was an advocate. After putting in 7 years in the profession, he took the examination and became a civil judge. Subsequently, when he was serving as a civil judge, he took the examination for direct recruitment as a district judge.
No, that's not correct.
I'm sorry, my lord.
He did both when he was an advocate. Both he did as.
My lord, I bow down to what your lordship is saying, my lord. I'll correct myself to that extent, my lord. He did apply for, my lord, to appear in the examination as a district judge when he was still an advocate. But, my lord, his appointment came after, my lord, he was already serving as a civil judge. He was, my lord, I'm sorry, my lord, not civil judge, Munsif magistrate. So, my lord, this person, my lord, was then given liberty by the High Court on his application to demit office, my lord, as a as a Munsif magistrate and get posted, my lord, as district judge. This was challenged by Deepa and some others, my lord, and the High Court, my lord, held, the learned single judge held that this could not be done. The division bench held that, upheld that judgment. Now, those are the very short facts, my lord, of the 4 questions which your lordship has raised.
So whether that Rajneesh is in service now,
Yes, he is in service now.
he is protected
He is protected, my lord.
by this court.
Yes, he is in service now, my lord. And what is more, my lord, the state has taken a stand categorically in his favor. Now, my lord, therefore, I am only going to address your lordship as the counsel for the state on A and B questions. Not on C and D questions, my lord, I am not concerned with that. A and B question, whether a judicial officer who has already completed 7 years in bar, being recruited for subordinate judicial service, would be entitled for appointment as additional district judge against the bar vacancy. Whether the eligibility for appointment is to be seen only at the time of appointment or at the time of application or both. I will not address, my lord, the other 2 questions. My lord, 233, as your lordship has seen many times now, has 2 conditions. One is, I am going to call that, my lord, the 7-year rule, and the second one is, my lord, the in-service rule. These are the 2 parts, my lord, of 233. On 7 years rule, my lord, my respectful submission is that the judgment in Vijay Kumar Mishra is correct for the reasons given there, particularly, my lord, 4 paragraphs, my lord, of the judgment of Justice Sapre. If I may just place, my lord, those 4 paragraphs, my lord, and move on from this topic. The proposition is that,
The thing is given is that selection and appointment
yes,
are 2 separate things.
separate things, and appointment only takes place when he is actually appointed. The question, my lord, is whether the proposition that we are therefore making is this: a candidate can become eligible under Article 233(2) of the Constitution after putting in 7 years of practice, but the same does not have to be continuous leading up to the date of the appointment. It can be 7 years at any stage of his working life. This is the proposition.
Anyhow, so you want to enact the argument of Arvind Datta that suppose he practices for 3 years and then goes back somewhere for
Yeah.
10 years,
Yes,
again practices for 4 years,
yes,
will be eligible.
he would be, my lord. Because, my lord, he has put in 7 years at some stage of his career. But of course, my lord, as far as this particular person is concerned, he has put in 7 years continuously. But there is a gap between him putting in that service and, my lord, the appointment. My lord, my lord is absolutely right. He was, what? There is no gap between the application and the advocacy.
On the date of the application, he had continued.
He was,
7 years of
yes,
practice.
correct, my lord. But, my lord, on the date of appointment,
Prima facie, we are of the view
yes,
is that the eligibility has to be considered on the date of the application, not on the date of the appointment.
very well, my lord. But I'm submitting, my lord, that even if on the date of appointment my lord, even if there is a gap between the date of application and the appointment, and even if your lordship were not to take that period as being, my lord, covered, even then 233 is satisfied. That's what I'm submitting, my lord. Because,
Sorry,
yes, my lord, just let me place those 4 paragraphs, my lord, of Justice Sapre's judgment. Vijay Kumar Mishra, your lordship is looking at from page 76, 876, volume 3. Paragraph is 21 onwards.
Justice Sapre would start from para 50.
Yes, correct, my lord. Justice Sapre starts from
You want to read from para 21?
21.
Mr. Ranjit Kumar.
Mr. Ranjit Kumar, because he, my lord, makes a very pointed submission. Mr. Ranjit Kumar, Solicitor General, appearing for the respondent, High Court, however, contended that the word appointed occurring in 233(2) of the Constitution should necessarily include the entire selection process, starting from the date of submitting an application by the person concerned till the date of his appointment. It is his submission that if any such person is found to be in the service of the union or the state, as the case may be, on the date when he has applied, then such person would suffer the disqualification prescribed in clause 2 of article 233 and would neither be eligible nor to apply nor be eligible for appointment to the post of district judge. So the clear, my lord, submission. Para 22. This submission, though looks attractive, is not acceptable. Neither the text of the article nor the words occurring in article 233(2) suggest such an interpretation. Indeed, if his argument is accepted, it would go against the spirit of article 233(2). My learned brother, for rejecting this argument, has narrated the consequences which are likely to arise in the event of accepting such argument, and I agree with what he has narrated. In my view, there lies a subtle distinction between the words selection and appointment in service jurisprudence. Praful Swain is referred to. When the framers of the Constitution have used the word appointed in clause 2 of 233 for determining the eligibility of a person with reference to his service, then it is not possible to read the word selection or recruitment in its place. In other words, the word appointed cannot be read to include the word selection, recruitment, and recruitment process, because they were trying to, my lord, injunct the whole of that process. In my opinion, there is no bar for a person to apply for the post of a district judge if he otherwise satisfies the qualifications prescribed for the post while remaining in service of the union and state. My lord, it goes further than saying that a person has applied when he was an advocate, but he has been appointed when he was in service. It goes beyond that and says that even if you have applied on the date when you are in service, it is perfectly all right. It is only at the time of his appointment if occasion so arise that the question of eligibility arises. Eligible is only to be seen on the date of appointment. Denying such person to apply for participating in selection process when he otherwise fulfills all conditions prescribed in the advertisement by taking recourse to clause 2 of 233 would, in my opinion, amount to violating his rights guaranteed under 14 and 16. It's a settled principle of the rule of interpretation that one must have regard to the subject and object. To interpret a statute in a reasonable manner, the court must place itself in the chair of the legislature. So done, the rules of purposive construction have to be resorted to so that the object is fulfilled. Similarly, it's also a recognized rule of interpretation, etc. So,
We heard you that we may not require further elaboration.
Lordship.
We may be subject to hearing them. Maybe we may not be inclined to go into this. Perhaps it might become academic.
Certainly, my lord. My second submission is, my lord, with regard to the in-service condition. The so-called in-service condition, my lord, in my respectful submission, is really a matter of form rather than substance. It can very easily be dealt with in the facts of any given case. I'll take, my lord, this particular case itself. The Kerala rule says The Kerala rule says that appointment is on the date he joins a post. So when he joined the post, after, my lord, he was discharged or allowed to step down from, my lord, the position of a municipal magistrate. It is not the date on which he is offered the employment that, my lord, is relevant. This, my lord, helps us because on the date when he is offered the employment, many of these people have been in service. They have then resigned or, my lord, have been discharged, whatever. Now, the reason why, my lord, I say so is this. Two things, my lord. Number one, my lord, ultimately, it is a question of, my lord, offer and acceptance. It's a contractual situation. So the letter which offers appointment is only an offer. At that stage, he is not yet an appointed judge.
So the contra interpretation accepted.
Yes,
Nobody would even venture to write the examination.
exactly, my lord.
Not resign and come, and nobody can.
No,
say-
then, my lord,
nobody
it's
can
not
say what
practicable.
would happen.
It's not practicable.
Nobody would come.
Not practicable, but, my lord, legally also
He has to
unnecessary.
decide to give up this post.
Yes,
Then he has to decide if he doesn't get into a district judge post,
Yes.
he has to go and practice because he can't go back.
no, he has to go to practice.
Come. and-
He can only go and practice again, my lord.
That's correct.
So therefore, my lord, what we are saying is that treat it from a point of view of principle. After all, my lord, every contract of employment is a contract. So when he is offered that employment, that's not the date of appointment. It's when he accepts it.
It is like civil service, no, IAS and IPS, you can write. You continue,
Yes,
you defer it and then you can write again.
correct, my lord.
If you get postal service, you can still go for
You can
IPS,
go for a better thing.
You can go
Yes.
for IAS, you can go for IFS.
Correct.
Commission notes that and says in all these other services,
Yeah,
lower service,
No, no.
but,
It will not be necessary, but we were said interpreting a constitution.
Yes,
In common parlance, if a person who is selected as an Ayat Tahsildar can apply for IAS, central service,
correct.
while he is working as a,
True, my lord. And here, my lord, what I'm saying is, my lord, there is no problem with him actually being in service. When he is in service, he is then offered employment in a different service. He then decides to accept it or not to accept it. My lord, there can be a situation. I don't know.
his service will, that category will start from day one.
Yes, it will not, my lord, then what
You
will,
will have to forgo whatever benefits or advantages, disadvantages of the past service.
that's all, my lord. That's all. But he will accept that appointment.
And that will be disastrous for the institution as well.
Yes.
Somebody
Then
would-
you will be losing, my lord. Your
Then
lordship
go
will
back
losing.
and finish the recruitment.
Your lordship will be losing somebody who is admittedly, my lord, a very competent person. Now, my lord, one thing I should show your lordship, my lord, this principle of acceptance and offer and acceptance is, my lord, confirmed, not this. My lord, the rule, the Kerala rule, my lord. Yes. What is it? So, my lord, page, volume 4.
Just a minute.
Yes, I'm sorry. My lord, I want to show your lordship, my lord, the Kerala State and Subordinate Service Rules 1958. Volume is, my lord, 4.1 of your lordship's compilation. Don't have to take it, my lord, I'll read it because it is in support of this proposition. Definition 2.1, appointed to a service. And my read, my lord, in these rules, unless there is anything repugnant in the subject context, appointed to a service, a person is said to be appointed to a service when in accordance with these rules or in accordance with the rules applicable at the time of as the case may be, he discharges for the first time the duties of the post borne on the cadre of such service or commences the probation, instruction or training prescribed for members. So, my lord, only when he starts working on the service, my lord, is he appointed? The word, my lord, in 233 is clearly appointed. So, my lord, this is, my lord, what I wish to say about, my lord, the second condition in service. It's a matter of form. The substance can always be, my lord, achieved. For instance, my lord, you can even give a letter saying that we are offering you this subject to you accepting, or you can say that we are offering appointment. Now, there are three things, my lord, I will just state, my lord, and that's all that I wish to do, my lord. First of all, my lord, please remember that Dhirajmore gave a lot of weightage to the quota. Please remember, my lord, that the quota was not a constitutional requirement.
There is no quota as such.
233 has no quota. How did the quota come? Quota came because
State commission.
your lordships, my lord, went into the question.
All India Judges Association 1.
All India judges, etc.
Association 1.
Yes,
20, 75, 25, 25.
all that.
Yeah.
And then 10,
Then 75,
25, 10,
75, 10 and 40.
40. Yes. Yes, my lord. We have gone through that entire process, my lord, because all India judges kept appearing in the list from time to time. It still is appearing, my lord. Now, what I'm trying to say is this, my lord, that quota is not constitutional. My lord, that quota is created because your lordships felt the need was there to create it. And mind you, my lord, the rules followed that creation.
Earlier to City Commission and All India Judges 1 first judgment.
Yes.
The appointments were only through promotion.
Through promotion.
There was no direct district, there was no avenue for the lawyers to directly come in.
Does not.
It has been provided by the first judgment so as to give incentive
Yes.
to the lawyers to join and so that the fresh blood is infused.
Lordship.
So that quota has come by, not by the constitution, by our judicial process.
By judicial pronouncement.
Then to give some incentive to the in-service candidates, that LCDA came.
Limited competitive examination. Then it was found that the limited competitive examination was not producing.
Not having enough number of candidates.
Correct.
So
it was reduced.
25 was brought to 10.
Lordship.
Now we are again enhanced it to 25.
Right. And your lordship will recollect, my lord, after all that, the state of West Bengal had come before your lordship and said that our limited competitive category has been exhausted and will remain exhausted for a long time. Please allow us to go back to 25%. That was in the other matter, my lord.
That we already decided.
Yes, your lordship has decided that.
Because of the wording there, the judgment.
Yes.
It says senior civil judge.
Yes. And my lord,
Yes, now how do you interpret the senior civil judge?
Yes.
Now they say in some state they'll say 10 years as civil judge. Again, it will be of no use again.
Correct.
It will not enable fresh talent to emerge.
Yes.
You have to become from junior division to go to senior division. Language there for about 8 years. Thereafter, by the time the candidates would get jaded.
Lordship, my submission is, the next one is that therefore, my lord, the rules were pursuant to your lordship's order. In fact, my lord, in order to give effect to the order, the state governments were all called and they all agreed to, my lord, develop those rules, create the rules. One or two states probably had, my lord, direct appointment at that point of time, but most didn't have.
In Bombay High Court,
Yes.
the city civil judges used to be appointed directly from the bar.
Right.
There was no examination or something of that sort. It was sort of an invitation.
Yes.
Gujarat was part of Bombay first. So it followed the Bombay practice.
Yes. So therefore, my lord, there was some of it, but most high courts didn't have. Most high courts introduced it for the first time after your lordship's judgment and after the rule was framed in accordance with your lordship's judgment. So the question of, my lord, going the reverse way and giving an interpretation to 233 based on the rules, my lord, does not arise. The second thing I want to say is this, my lord. My lord, the second thing I wanted to mention is this. there is a lot of emphasis, my lord, again in Dhirajmore about cutting down somebody else's quota. My lord, in my respectful submission,
When there is no quota in the constitution,
my lord,
there is no question of cutting down.
right, my lord, that's my first submission. The second submission is this, my lord, that if on interpretation, your lordships are satisfied that this person, my lord, who has put in 7 years as advocate and subsequently has gone to the judiciary, if this person is covered by 233(2) and is capable of direct appointment, then, my lord, he is entitled to be part of the 25%. So it depends on the interpretation. If the interpretation is that he is outside direct recruitment, then there is a cutting down. But if he is inside the direct recruitment on an interpretation of 233(2), in that event, my lord, you are not cutting down anybody. It is only that the zone of consideration is larger.
It is not group centric or a community centric. It's
Exactly.
on the institutional, it's on institutional centric. No?
That's right.
The constitution, it facilitates every institution to flourish, which means, you have to pick the best of the talent available. That's the objective behind it.
And there is nothing in 233 which prevents it. my lord. That's the submission. My lord, those are my submissions. Not this.
So to start today or tomorrow?
As my lord,
Okay. Can you finish in 5 minutes?
I'll take 10-15 minutes.
So Marnapalli, you are on which side?
My lord, I didn't have the place that side, so
That was, I was wondering, yeah, I was just wondering to see on that side.
I've been affected by the Maharashtra.
When I saw you,
No, I didn't.
I recollected that our Nagpur chamber meeting.
I'll appear that side tomorrow for a few minutes.
Therefore, I will.
The Lordship said, my lord, before.
There is a request on behalf of the advocates preparing for the judicial service to please allow the intervention on behalf of.
No intervention. Only those parties who are there.
Yes.
Their career will be affected, Lord. Sir. So
What career would be affected?
No,
they are,
Just because the live streaming is there, somebody has to show that he is arguing in the case.
that is not, Lord.
No more intervention. Whatever timetable is given, that will be followed.
please, your lordship.